Chapter 10 Interstate Cases Introduction. The problems of establishing and enforcing a support order are compounded when the absent parent and dependent child live in different states. Jurisdictional hurdles may prevent the child's caretaker from bringing the support action in his or her home state. Yet, the child's caretaker may not be able to bear the expense of bringing an action in another state. In the past, these problems enabled absent parents to avoid child support obligations by fleeing the abandoned family's home state and remaining beyond the process of its courts. Attempts to enforce the obligation in the absent parent's home state often were frustrated. Long-arm statutes were often inapplicable, and criminal enforcement proved defective because extradition was time-consuming, expensive, and overly drastic in the eyes of those involved. As Americans have become more mobile, the interstate enforcement problem has become more acute, forcing more and more abandoned families onto the welfare rolls. Early child support legislation was ineffective. The Uniform Desertion and Non-Support Act, drafted in 1910 by the Commissioners on Uniform State Laws and ultimately adopted in 24 states, made it a criminal offense to desert or fail to support a wife or child in need. The act, however, did not provide any civil remedies for non-support, nor did it provide for interstate enforcement when the father fled the state. In response to the need for a simple, inexpensive, and consistent interstate process, the Commissioners began studying the issue in 1944 and adopted the Uniform Reciprocal Enforcement of Support Act, Euresa, at the 1950 American Bar Association, ABA, annual meeting. Euresa provides a uniform process for using the courts of another state without traveling to that state or becoming subject to the jurisdiction of that state's courts for other purposes. To achieve this, the Act establishes a two-state legal proceeding. The Euresa Proceeding begins with the filing of a petition in a court in the abandoned family's home state, the initiating state. The judge of that court reviews the pleadings to determine whether the allegations establish an existing duty of support and whether the responding state appears to have jurisdiction over the absent parent. If the judge finds these elements, the proceeding is certified to the proper court in the responding state, where the support obligation is established and enforced. Some states use the same procedure between two different counties within the state. The 1950 version of Euresa also provided for criminal enforcement through extradition, or rendition in the language of the Act. For the Act was amended significantly in 1952 and 1958 and revised in 1968. The 1958 amendments incorporated a registration procedure that provides for summary registration and enforcement of existing support orders in the absent parent's home state. The 1968 revisions specifically provide for paternity establishment, among other things. All 50 states plus the District of Columbia, Guam, Puerto Rico, the Virgin Islands, and American Samoa have adopted some form of Euresa or similar legislation. The basic mechanics of the Act are the same in all states, but some states have modified or omitted certain sections to comply with existing procedures and enforcement techniques. The amendments to and revisions of the Act have been adopted by some states and not by others. Consequently, the effectiveness of the Act may depend upon the initiating state's knowledge of the responding state's capabilities and procedural necessities. In addition, many state 4D agencies have shown little commitment to interstate establishment and enforcement in the past, and state courts, when acting as the responding jurisdiction in a Euresa proceeding, have been a frequent haven for non-complying absent parents. As a result, the original aims of the Commissioners have remained unfulfilled. Congress reacted to this problem with the Child Support Enforcement Amendments of 1984, PL 98-378, which contain several provisions pertaining to interstate support enforcement, as follows. States must enact and implement procedures for interstate wage withholding. States must enact and implement other proven enforcement techniques and apply them to interstate cases. See Chapter 8. States must enact and implement expedited judicial or administrative processes and use them for interstate establishment and enforcement. Federal incentive payments will accrue to both states involved in an interstate case. Significant federal funding will be available in the fiscal years commencing October 1, 1984. To support special demonstration projects testing innovative methods of interstate enforcement and collection. Federal tax refund interceptions, a powerful interstate remedy, will be available for non-AFDC 4D cases with tax refunds payable after December 31, 1985, and before January 1, 1991. These mandatory improvements should make interstate enforcement a more uniform and effective procedure. No longer will orders need to be established in cases where an order already exists, and no longer will obligors have an opportunity to convince a responding court that their obligations should be excused or severely diminished. Despite this optimistic forecast, state and local 4D agencies, the courts, and 4D attorney must increase their commitment to effective interstate case processing until each link in the chain accepts full responsibility to carry out faithfully the functions delegated to it by statute or cooperative agreement. The interstate problem will plague the 4D program. The remainder of this chapter discusses the major interstate procedures and remedies, including interstate wage withholding, proceedings to establish and enforce support obligations under Part 3 of Euresa, registration under Part 4 of Euresa and other statutory provisions, comity, full faith and credit, actions in federal court pursuant to 42 U.S.C. 660, requests for enforcement pursuant to 42 U.S.C. 654. and seizure of in-state wages and bank accounts of obligors who reside out of the state or out of the country. Interstate income withholding. One of the most significant provisions of the Child Support Enforcement Amendments of 1984 was the interstate income withholding requirement. This section discusses both the statutory requirements and efforts by child support enforcement program leaders to ensure that the procedure is implemented consistently and efficiently. Federal requirements as discussed in Chapter 8. The Child Support Enforcement Amendments of 1984 require each state to establish a system under which support payments will be withheld from the wages or other income of non-complying obligors. 42 U.S.C. 666, B1. The federal statute further requires each state to extend its wage withholding system to income derived within such state in cases where the applicable support orders were issued in other states, in order to assure child support owed by absent parents in such state or any other state will be collected without regard to the residence of the child for whom the support is payable or of such child's custodial parent. 42 U.S.C. 666, B9. While the statute is very specific regarding the procedures that must be followed in wholly intrastate situations, it provides little guidance as to interstate procedures. The regulations set forth a general procedure for initiating wage withholding. First, the 4D agency in the state where the custodial parent applied must inform the 4D agency in the state where the absent parent is employed of all information necessary to carry out the withholding. The employing state must provide advance notice of the proposed withholding, opportunity to contest the withholding, and notice to the employer. The law and procedures of the state of employment are to apply except with respect to when withholding must be implemented. The Child Support Project of the American Bar Association's National Legal Resources Center for Child Advocacy and Protection, in conjunction with Oaks and the National Conference of State Legislatures, has drafted a model interstate income withholding act, which many states may wish to adopt in implementing the interstate wage withholding requirement. The Social Security Act requires each state to appoint an agency to administer the wage withholding procedure. The comments to the Model Interstate Income Withholding Act refer to these agencies as income withholding agencies of the requesting and the forum states. The former is the state in which the children reside, the latter the state in which the obligor resides or works. This discussion is adapted from those comments and uses the same terminology. The term agency refers most often to the 4D agency or the courts, depending on which entity administers the procedure. Responsibilities of the requesting state agency. The Model Act requires the income withholding agency to request interstate withholding on behalf of its current 4D clients, as well as for in-state and out-of-state residents who apply for this service through the 4D agency. This corresponds to the federal requirement for interstate cases, which requires that income withholding services be made available to 4D agency clients, both AFDC and non-AFDC. Social Security Act Sections 466, B2, 42 U.S.C. 666, B2, non-AFDC families specifically may apply to the 4D agency to take advantage of the withholding remedy, although many states allow non-AFDC families to institute this remedy through a private right of action as well. See, for example, cal.sif.co.dan. Sections 4701b1, text.fam.co.dan. Sections 14.091. In addition, the agency can be asked to initiate income withholding for a non-resident custodial parent if the underlying support order was issued in that agency's state. Such a request is likely to occur when the obligee has moved out of state and all the relevant documents, including payment records, are still in possession of the enacting state, or when the obligee moved out of state and was receiving payments directly from the obligor without ever using the agency services of a new state. In any event, the obligee also could elect to go to the agency where she or he now resides for purposes of initiating an interstate request for income withholding. The procedure requires the requesting agency to compile and transmit all documentation required by the forum state, along with any subsequent modifications of the support order. If the requesting agency learns that a hearing has been scheduled in the forum jurisdiction, it must notify the obligee of the date, time, and place of the hearing and of his or her right to attend the hearing. Entry of order in forum state upon receiving the request for income withholding and the accompanying documentation. The forum state's income withholding agency will enter the support order. Entering may be accomplished by filing the document with the appropriate court or agency. Entry of a sister state support order under the Act is the cornerstone of the interstate withholding procedure. Once the order is entered, it is enforceable by the forum state's own income withholding law with some specific minor modifications to accommodate interstate needs. A support order entered in the agency or court essentially becomes an order of the forum state for the sole and limited purpose of obtaining income withholding. The Model Act makes it clear that the entered order does not confer jurisdiction on the court or agency for any other purpose, such as resolution of disputes over custody or visitation or modification of the original support order, whether prospectively or retroactively. See discussion of modification below. Notice to the obligor on the day the out-of-state support order is entered under this procedure. Notice of the proposed withholding must be sent to the obligor. The forum state will use its regular notice procedures to notify the obligor of the intent to withhold his or her income. Specifying when advance notice should be sent to the obligor is significant. Under the new federal law, if the obligor contests the withholding, the state must determine within 45 days of such notice whether the withholding is appropriate. 42 U.S.C. 666. B4A. The notice should be served according to usual state practice and contain the same information required in an intrastate income withholding notice. According to Section 466. B4A, of the Social Security Act, as added by the Child Support Enforcement Amendments of 1984. The notice must alert the absent parent to the proposed withholding and to the procedures to follow to contest the withholding. The notice will state a method and a time period within which the parent must contact the court or agency in order to contest withholding, and explain that failure to do so will result in the implementation of withholding. The only added requirement of the Model Act is that the notice indicate that the proposed withholding is based upon an out-of-state support order. The Child Support Enforcement Amendments of 1984 provide an exception for those states that were operating an income withholding system prior to the date of enactment of the 1984 amendments. These states need not meet the advance notice requirements of the amendments so long as their existing procedures meet due process requirements. Social Security Act Sections 466, B4B, 42 U.S.C. 666, B4B. Documentation. The following documentation is required for the entry of a support order of another jurisdiction. A copy of the support order with all modifications. The ABA model law calls for a certified copy. A copy of an income withholding order or notice, if any, still in effect. The ABA model law calls for a certified copy. A copy of the portion of the rendering state's income withholding statute that sets forth the requirements for obtaining income withholding under the law of that state. A sworn statement of the obligee or certified statement of the agency of the arrearages and the assignment of support rights, if any. A statement of the name, address, and social security number of the obligor, if known. The name and address of the obligor's employer or of any other source of income of the obligor derived in the forum state against which income withholding is sought. The name and address of the agency or person to whom support payments collected by income withholding shall be transmitted. The Model Act requires the forum state agency to take steps to correct faulty or incomplete documentation without returning it to the requesting agency, when possible. This should limit unnecessary delays and advance Congress' intent that income withholding be effected expeditiously. In addition to providing for correction of errors, the Act requires the agency and court to accept or process documents that are correct in substance but not form. The hearing. If the absent parent requests a hearing, the forum state agency must notify the requesting agency. The Model Act provides a limited form of hearing: the entered support order, the existing income withholding order, if any, and the sworn or certified statement may be admitted into evidence, without any further proof or foundation required, and constitute prima facie proof that, without a valid defense, the obligee is entitled to income withholding under the law of the jurisdiction which issued the support order. This means that the amounts of current support and arrearages are as stated and that the triggering event, that is, amount of arrears required to commence withholding, of the jurisdiction that rendered the support order has occurred. Once a prima facie case is established, the Model Act shifts the burden of proof to the obligor. The obligor's defenses are limited to those permitted by the Child Support Enforcement Amendments of 1984. According to the 1984 amendments legislative history, these defenses are restricted to mistakes of fact, which include errors in the amount of current support owed, errors in the amount of arrearage that had accrued, or mistaken identity of the alleged obligor. The obligor cannot contest the proposed withholding on other grounds, such as the inappropriateness of the amount of support order to be paid, changed financial circumstances of the obligor, or lack of visitation. H.R. Rep. Number 98527, 98th Cong. 1st Sess. 33, 1983. Such claims, though important, must be pursued through a separate legal action in the state that has jurisdiction over the original action. In addition to mistakes of fact, 3 other defenses are permitted. These include 2 collateral attacks on the original judgment, which could be raised in the state that issued the original order if that state sought to enforce it. These attacks include charges that the court which issued the original support order lacked jurisdiction, if this had not been litigated previously, or that there was fraud in the procurement of the order judgment. See Griffin v. Griffin, 327 U.S. 220, 1945, Scholes and Hay, Conflicts of Law 24.14, 1982, Leffler, American Conflicts of Law, 1977, Restatement, 2nd, Conflicts of Law 105, 1971, Fraud in the procurement of the support order refers to fraud in the actual obtaining of the order. For example, the defendant was lured into the jurisdiction in order to obtain personal jurisdiction. The third defense concerns the Statute of Limitations. See Chapter 6 for a discussion of statutes of limitations as applied to child support orders. Choice of law in keeping with a major principle of the Model Act that the forum states regular income withholding laws and procedures be applied to the greatest extent possible. Most choice of law questions are resolved in favor of the local law of the forum state, making it simpler for decision makers and employers to administer the procedure. Only 3 issues are determined by the law of the state that issued the order. The first issue concerns questions about the interpretation of the original support order, including questions about the amount and form of payments and the duration of the order. For example, the law of the state issuing the order would determine the meaning of the term minor child as used in an order, whether support may continue beyond the age of majority for a college student, and whether in-kind payments would be credited against the support obligations. The law of the state that issued the original order also determines the amount of support arrearages necessary to require the commencement of withholding. This should pose no problem as no request should be made until this condition is met, and the request should include a copy of the section of the state's withholding law containing this condition. Third, the law of the state issuing the support order determines what items are included as arrearages that may be enforced by income withholding. These could include interest on late payments, attorney's fees, or court costs. Another potential conflict of law concerns statute of limitations provisions. Usually, in interstate cases, there will be no real conflict. If a judgment is rendered in the forum state, the statute of limitations for that state obviously will not have told, and enforcement can continue in that state. If the statute of limitations has told in the initiating state, no judgment can be rendered for forwarding to another state, and there is nothing for the forum state to enforce. A judgment rendered in the initiating state that would have been barred by the statute of limitations in the forum state nonetheless must be enforced in the forum state. Restatement, 2nd, Conflicts of Law, Seconds 118, 1. 1971. This should not prove to be difficult for local judges and hearing officers. Under general conflicts of law principles, a judge may assume that the law of the state whose support order is being considered is the same as the law of the forum state until one of the parties demonstrates otherwise. Obviously, when a question is raised, it would be in the interest of the requesting state to submit an appropriate reference to the case and statutory law of the state that issued the order. Discovery. If the obligor successfully meets the burden of establishing a defense, the Model Act provides that the court shall continue the case to allow the obligee to collect evidence. It provides further that if the obligor acknowledges some liability, current support, for example, the court shall require income withholding for that amount while the dispute as to other issues is resolved. The Act specifically allows use of depositions, written discovery, photographic discovery such as videotape depositions, as well as live testimony in person and on the telephone. The Act includes a procedure for taking depositions in the requesting state, similar to the procedure in Euresa. The withholding order and notice if the obligor does not request a hearing, or if a hearing is held and the court or agency determines that withholding is proper, it issues an income withholding order or notice to the absent parent's employer or other payer. The same procedure applies for both intrastate and interstate cases. See Chapter 8. Entry of a support order or notice for withholding purposes does not nullify any other support order that may exist whether issued by the forum state or another state. When 2 or more orders exist for the support of one child by an absent parent, any amount collected will be credited against both orders. Such a situation may exist. For example, if there is both an original support order and a subsequent Euresa order, amounts withheld are to be credited against both orders. Payment transmission. Income withheld in interstate cases is to be paid to the income withholding agency of the forum state. which in turn will forward it to the requesting agency or person. If the forum state uses a different entity such as a private agency or bank to collect and disperse support payments, as allowed under 42 U.S.C. 666 B5, this entity also should collect and disperse funds withheld in interstate cases under the Model Act. Modifications: if the rendering state modifies a support order entered in the forum state, the forum state must take the necessary steps to modify the amounts withheld accordingly. Conversely, the agency in the forum state must notify the requesting agency when the obligor's source of income has shifted to yet another state. When there has been merely a shift of a source of income within the forum state. For example, if the obligor gets a new job, the forum state agency will take necessary steps to obtain withholding against the new source of income, as it would with any other in-state income withholding case. 45 CFR 303.100, D3, some states have facilitated the task of identifying new income by requiring employers to notify the agency of any change in the obligor, employee's status, including the name and address of a new employer, if known. ND. Cent. Code Seconds 140909.1, 6. 45 CFR 303.100, DX, requires that states impose an obligation on the employer to provide this information to the state. Part 3 Euresa Proceedings. Unfortunately, income withholding will not be possible in all interstate cases. In many cases, an enforceable support order will not exist. In others, the absent parent will not have identifiable income to withhold. These instances necessitate proceedings under Euresa unless there would be responding state as an administrative process. Where administrative remedies exist, they must be exhausted before judicial remedies can be sought. This section discusses Euresa proceedings in which the court in the responding state is asked to make an independent determination of the absent parent's support obligation. This type of proceeding will be referred to as a Part 3 Euresa action to differentiate it from proceedings under the Euresa registration provisions. Registration, which is provided for by Part 4 of Euresa, is discussed separately. Parties: any person to whom a duty of support is owed may initiate an action in the court having jurisdiction to handle Euresa actions, asking the court to enforce that duty. A petition on behalf of a minor may be brought by any person having legal custody. In some states, mere physical custody will suffice. See COI v. COI, 163A2D 333, D.C. Mun. App. 1960, Clearwater County, Minnesota. V. Petrash, 198 Cullo. 231, 598 P2D 138, 1979. If the state is furnishing financial assistance to the plaintiff, the state has the same right to initiate a proceeding under this act as the individual obligee for the purpose of securing reimbursement for support furnished and of containing continuing support. This section has been held to support an action for reimbursement of AFDC paid to an obligor's dependent during periods in which no court order for current support existed. State v. Urban, 463A2D 194, RI 1983, Kinney v. Kinney, 453A2D 1321, 122 NH 1165, 1982. This is true even where the parents are divorced but where the divorce court did not enter an order for support. State Ex-Rel. State of California Ex-Rel. Santa Barbara County v. Lagoy, 54 or .app. 164, 634 P2D 289, 1979. Conversely, if the divorce court entered an order specifically stating that the absent parent shall not be required to pay child support, the Euresa court may be unable to order the absent parent to reimburse the state because no duty of support existed during the period AFDC was paid to the family. Chance v. Laporsky, 43 MD.app. 84, 402 A2D 1329, 1979. The obligee need not be joined as a party to such an action. Roulette v. Roulette, 221 NW2D 645, ND 1974. If the obligee is financially able, he or she may employ private counsel to initiate a Euresa action. If not, he or she may apply for 4D services. The 4D agency will refer the matter to the relevant local official, usually the prosecuting attorney, who is required by the Act to file the action on behalf of the dependents. The petition. The Euresa statute sets forth minimum information requirements to be included in the petition, as follows: names of the parties, address and, so far as known to the obligee, the circumstances of the obligor, names, addresses, and circumstances of the children for whom support is sought, all other pertinent information. The statute further invites the petition drafter to include a description and photograph of the respondent to assist the responding state in identifying and locating him. Most states' Euresa statutes require the petition to be verified, authenticated. The petitioner may not be charged a filing fee or any other costs. The initiating or responding state may seek to recover its costs from the absent parent by making a prayer in the responding court. Initiating court's role. The role of the initiating court is limited. The court makes a finding based on the petition and, in some jurisdictions, after an ex parte hearing at which the obligee testifies. The finding consists of two components: 1. That it appears the obligor owes a duty of support to the plaintiffs, and 2. That it appears the court in the responding state has jurisdiction over the obligor or his property. 18. This review is not a complicated process. It resembles a determination of whether a complaint in an ordinary civil case states a claim on which relief may be granted, or a determination of probable cause in a criminal case. Watson v. Dredding, 309 A2D 493, D.C.App. 1973. Kirby v. Kirby, 338 Mass. 263, 155 NE2D 165, 1959, Saunders v. Saunders, 650 SW2D 534, text.cif.app. 1983. The review as to jurisdiction is similarly brief. The court normally determines only that the obligor is likely to be physically present in the responding state. If the obligor contests the sufficiency of the petition, the law of the responding jurisdiction determines the issue. Thibaud v. Thibaud, 133 GA.app. 154, 210 SE2D 340, 1974. These two findings are entered of record in the judge's certification. The certificate may contain a request that the responding state arrest the obligor, if arrest is permissible under state law and the court is persuaded that he or she might flee in response to being served with a Euresa process. The certificate often contains an order directing the court clerk to forward the pleadings and certificate to the responding jurisdiction. Initiating courts customarily enter a recommendation as to the amount of support the responding court should order the absent parent to pay. The recommendation does not constitute a support order, and Euresa provides for no such recommendation. Mossberg v. Kaufman, 6 Can.app.2D 428, 629 P2D 745. 1981. Nor does the recommendation bind the responding court's adjudication of the merits of the case, although it may constitute prima facie evidence of the children's present needs and circumstances. Gambino v. Gambino, 396 So2D 434, La.app. 1981. State of Minnesota, Clay County, on behalf of Litcher v. Doty, 326 NW2D 74, ND 1982, forwarding documents to the responding jurisdiction. The court clerk forwards 3 copies of the petition, with attachments, and 1 copy of the initiating state's Euresa statute to the responding state. 1 copy is for the responding court, 1 for the prosecuting attorney in the responding jurisdiction, and 1 for service on the absent parent. If the clerk of the initiating court does not know the identity and address of the responding court, he or she may send the documents to the State Information Agency in the responding state, which will forward them to the proper court. Other duties of the State Information Agency include the following: compile a list of the courts and their addresses in the state having jurisdiction under the Act and transmit it to the State Information Agency of every other state, and upon the adjournment of each session of the legislature, distribute copies of any amendments to the Act and a statement of their effective date to all other state information agencies. Maintain a register of lists of courts received from other states and transmit copies promptly to every court in the state having jurisdiction under the Act. Use all means at its disposal to discover the location of the obligor or his or her property, or forward the case to the State Parent Location Service. The National Child Support Enforcement Association has prepared a list of state information agencies filing the action in the responding court. Upon receipt of the petition and attached documents, the clerk in the responding court is to docket the case and notify the prosecuting attorney of his action. The prosecutor must prosecute the case diligently. The prosecutor must first attempt to locate the absent parent on his own initiative, using all means at his disposal. If the prosecutor has insufficient information and is unable to locate the defendant, the statute directs the prosecutor to inform the court of what he has done and request the court to continue the case pending receipt of more accurate information or an amended petition from the initiating court. Many prosecutors routinely return the documents to the initiating state instead of making use of available state and local locate resources. If all prosecutors would comply with the location requirement in the statute, and make full use of all locate resources provided by the State 4D agency, the interstate process would be improved markedly. If the respondent is located in another judicial district or in a different state, the responding court has the duty to forward the documents to the district or state, and then to notify the initiating state. The court to which the documents are forwarded must treat the documents as though they were forwarded from the initiating state. Once the case is filed, the clerk of the court will pass the documents on to the sheriff for service. Some states treat the Euresa proceeding as a show cause situation. See, for example, State Ex Rel. Fulton v. Fulton, 31 or.app. 669, 571 P2D 179, 1977. In these states, a show cause order must accompany the pleadings. Some courts include in the show cause order a provision requiring the obligor to bring to court evidence of his income, that is, pay stubs, tax returns, cancelled checks. In other states, the action begins with a normal civil summons, advising the absent parent that he or she has so many days to answer in order to avoid the entry of a default order based on the allegations contained in the pleadings. If the court believes that the obligor may flee the jurisdiction, it may obtain the body of the obligor by appropriate process. Thereupon it may release him on his own recognizance or on his giving a bond in an amount set by the court to assure his or her appearance at the hearing. Jurisdiction. The test for personal jurisdiction is the same as for any in-person action brought in the responding state. See discussions in chapters 5 and 7. The Uniform Act refers in several sections to the court of the responding state obtaining jurisdiction of the obligor or his property. As noted in chapter 8, the U.S. Supreme Court's decision in Sheffer v. Heitner, 97 S.E.T. 2569, 53 led 2D 683, 1977, probably would prohibit an action based solely on the obligor possessing property within the jurisdiction, unless the action were limited to enforcement of a pre-existing judgment for arrearages based on an out-of-state order. With respect to subject matter jurisdiction, the statute and reported case law provide good direction. Section 32 of Euresa provides that participation in any proceeding under this Act does not confer jurisdiction upon any court over any of the parties thereto in any other proceeding. This provision generally has been construed to prohibit the responding court from considering counterclaims for divorce or property settlement. State Ex Rel. Schwartz v. 315 SW2D 867, Mo.app. 1958. Mestine v. Mestine, 54 calories.ch. 65, 245 California. App.2D 646, 1966. Blois v. Blois, 138 So2D 373, Flag.app. 1962. Counterclaims for custody and visitation. England v. England, 337 NW2D 681, Minnesota. 1983. State Ex Rel. Hubbard v. Hubbard, 110 Wis.2D 683, 329 NW2D 202, 1983. Pfeiffer v. Pfeiffer, 31 N.C.app. 486, 229 SC2D 700, 1976. Kraft v. Hertz, 182 NW2D 293, ND 1970. Gross v. Gross, 347 So2D 1099, Flat. App. 1977. Hoover v. Hoover, 246 SC2D 179, 181, SC 1978. Brown v. Turnbloom, 280 NW2D 473, 474, Michigan. App. 1979. Register v. Candlebinder, 216 SE2D 647, GA.app. 1975. Responsive pleadings. The Uniform Act does not provide specifically for a responsive pleading. Section 20, Hearing and Continuance, appears to assume that the obligor will enter a denial in person at the hearing, and substantiate his or her defense with evidence. At this point, the court is to determine, upon the request of either party, whether the matter should go to hearing immediately or whether a continuance should be granted. This reading of Section 20 would turn the initial hearing into a kind of arraignment, at which the court would decide whether there exists probable cause to hold a hearing on any of the obligor's affirmative defenses. Despite the lack of statutory guidance, many jurisdictions apply the normal rules of civil procedure, and responsive pleadings are filed at least where the obligor is represented by counsel. In a large percentage of cases, the obligor either fails to appear or appears and admits that a duty of support exists without filing an answer. The hearing. Once the disputed issues are determined, the case may proceed to hearing. The hearing should proceed like any other support proceeding, with the notable exception that the custodial parent is usually not available to testify. If the obligor asserts a defense, the prosecutor can have a difficult time proving the plaintiff's case, unless the hearing is treated as a show cause proceeding with the burden to produce evidence on the obligor. In most jurisdictions, once the obligor asserts a defense, the two parties are on an equal footing. Because plaintiffs are asking the court to grant relief, they must proceed first and must substantiate the allegations contained in the petition with admissible and credible evidence. The allegations, standing alone or in combination with the written testimony attached to the petition, are not sufficient to authorize the court to enter an order over a proper objection. Freina v. Rosenbaum, 399 So 2d 758, La.App. 1981. Lambrew v. Berner, 154 Me. 352, 148 A2d 697, 1959, Fuller v. Fuller, 37 N.J. Super. 106, 117 A2d 30, 1955, O'Hara v. Floyd, 47 Alabama. App. 619, 259 So 2d 673, 1972, Ivy v. Ayres, 301 SW 2d 790, Mo. 1957, Kirby v. Kirby, Supra, but see Saunders v. Saunders, 650 SW 2d 534, text.sif.app. 1983. Evidence. Clearly, as in other civil actions, the plaintiff bears the burden of proof. City and County of San Francisco v. Gibbons, 425 So 2d 992, La.App. 1983. Section 20 allows the plaintiff's attorney to ask the court for a continuance during which to gather submissible evidence to prove the existence of a duty of support, to substantiate the needs of the children, and to counter any defenses interjected by the obligor at the hearing. The case law provides some guidance regarding how this burden may be met. In Ivy v. Ayres, 301 SW 2d 790, Mo. 1957, the Missouri Supreme Court wrote, There, plaintiff may use other means of establishing her case. She may call the defendant as a witness, and it may be that she can establish her case by his testimony. She can also appear in person and testify, but one of the purposes of the reciprocal features of the laws pertaining to the support of dependents is to avoid this necessity. She also has available to her the use of depositions the same as has the defendant, which would include the taking of her own testimony by deposition. And apparently the deposition could be taken by the judge of the court in the initiating state. Citations omitted. Section 23 of the 1968 Act states that the same rules of evidence apply as in other civil actions in the court. Virtually all the evidence in Euresa cases comes from the obligor and the obligee. Indeed, the plaintiff may prove his or her case entirely with the testimony of the obligor. Phillips v. Phillips, 146 NE 2d 919, Mass. 1958. Section 22 of the Act makes any law granting a privilege concerning communications between husband and wife inapplicable to Euresa proceedings. Both husband and wife are fully competent to testify as to any relevant matter between them. In order to ensure open communication in the family, the common law granted spouses a reciprocal privilege regarding communications that occur during the marriage. Neither could be forced to give testimony against the other, and the party against whom such testimony would be used had a right to object and bar its use. The common law rule has found its way into many state statutes that could be used to bar the plaintiff from proving important elements of his or her case. For example, the obligor's ability to earn based on statements he or she made to the obligee during prior periods. Section 22 prevents application of the privilege to Euresa cases. The secondary methods of producing evidence under the Act are interrogatories and depositions. Interrogatories have been approved for use in Euresa cases. O'Hara v. Floyd, 259 So 2d 673, Alabama.App. 1972, Tanya v. Rosa v. 458 NIST 2d 869, 117 Miscellaneous. 2d 619, 1983. As to depositions, most states have adopted a rule similar to Federal Rule of Civil Procedure 32 or 3b, providing that the deposition of a witness or party may be introduced into evidence if the deponent is at least 100 miles away from the hearing. or is out of the state. In most Euresa cases, the petitioner falls into one of these categories. If not, the court may allow the deposition under a rule similar to Federal Rule 32 or 3E, which allows the use of a deposition if it serves the interests of justice and outweighs the importance of presenting the testimony of the witness orally in open court. This broad language should govern most Euresa cases, given the simplicity of issues involved and the clearly favorable policy of affording custodial parents an interstate remedy. It has been recognized that a plaintiff in a Euresa case can prove the case solely with a deposition. O'Hara v. Floyd, Supra, Ultimus v. Ultimus, 18 MD.App. 273. 306 A2D 581, 1973, Carpenter v. Carpenter, 231 La.638, 92 So 2D 393, 1956. Similarly, it has been held that Obligor's sole right to confront plaintiff's witnesses is through depositions and written interrogatories. Mazza v. Liar, 413 is 2D 244, 105 Miscellaneous. 2D 992. 1980. The court still has the discretion to refuse to admit the deposition if the distance the petitioner would have to travel is slight and it appears the petitioner is using Euresa solely for the purpose of presenting the case by deposition in lieu of live testimony. The 1968 version of Euresa specifically refers to using depositions. 34. The procedure for taking and using the deposition of the obligee generally follows Federal Rule 28. The deposition may be taken orally before an individual authorized to give oaths and act as a reporter in the obligee's state, or may be taken upon written questions. The obligor must be given notice in writing of the time and place of an oral deposition to allow for cross-examination. Thus, the testimony form, though duly executed under oath perhaps in the presence of the initiating court, does not constitute a deposition. Kirby v. Kirby, 338 Mass. 263, 155 NE2D 165, 1959, if the correct procedure is followed and the obligor fails to take advantage of his or her opportunity to cross-examine, he or she has waived the right to confront the witness and cannot object at trial. Daly v. Daly, 128 2D 510, 39 N.J. Super. 117, Uft. 123 A 2D 3, 21 NJ 599. 1956. The cross-examination may be conducted by the respondent's attorney, or through the submission of interrogatories. The 1968 Act recommends that the responding court appoint the judge of the initiating court as the official before whom the deposition is to be taken. The prosecutor in the initiating state would be available to conduct the examination and supervise transcription and transmittal of the deposition back to the responding court. Upon receipt of the transcript, the hearing can be rescheduled and resumed in the responding court. The costs of the deposition may be taxed as costs to the obligor. O'Hara v. Floyd, Supra. One crucial issue in any contested hearing may be the existence or non-existence of a duty of support. Where an order exists in another state, a certified copy of the order is competent to establish that the obligor owes a duty to support the children named in the order. State on behalf of McDonnell v. McCutcheon, 337 NW2D 645, Minnesota 1983, Mossberg v. Kaufman, 6 Can. App.2D 428, 629 P2D 745, 1981, in states that have not enacted Section 23 of the 1968 Act, a similar procedure is available under the Federal Authentication Act, 28 U.S.C. 1738. Once the order is placed into evidence, the obligor may contest the existence of the duty of support only by attacking the validity of the order, and his or her defenses are limited to those available to a defendant in an action or proceeding to enforce a foreign money judgment. One court has construed this provision to mean that once the order is received in evidence, the hearing becomes a show cause hearing to determine if there is any valid reason why the order should not be enforced as entered. Batchman v. Batchman, 196 NW2D 80, ND 1972. The other major issue at the hearing will be the obligor's ability to pay, as measured by his or her current income, or the income he or she could earn based on prior periods. This information can be obtained from the obligor through live testimony at the hearing, or in advance through discovery devices such as interrogatories and motions to produce documents. Subpoenas can be served on employers, banks, and acquaintances of the obligor. Clearly, the latter is the preferable method where time allows. Paternity. The 1950 version of Euresa, including the 1952 and 1958 amendments, did not specifically refer to paternity. As a result, A defense of non-paternity caused the courts considerable difficulty. Although there is a small minority position, for example, Aguilar v. Holcomb, 155 Callow. 530, 395 P2D 998, 1964, and Smith v. Smith, 11 Ohio Miscellaneous 25, 224 NE 2D 925, 1965. A majority of appellate courts have held that a court sitting in a Euresa case has jurisdiction to determine paternity. Perhaps the best discussion of this issue is to be found in the Supreme Court of Oregon's opinion in Clarkston v. Bridge, 539 P2D 1094, or Bank 1975. In Clarkston, a resident of Washington filed a petition under Euresa alleging that a daughter had been born out of wedlock and that an Oregon resident was the father. The petition was forwarded to Oregon, and the alleged father denied paternity and challenged the court's jurisdiction to determine the issue. On appeal, the Oregon Supreme Court relied on Sections 2b and 2f of the Act, which provide as follows: if the court of the responding state finds a duty of support, it may order the defendant to furnish support or reimbursement therefor and subject the property of the defendant to such order. Emphasis added, duty of support includes any duty of support imposed or imposable by law, or by any court order, decree, or judgment, whether interlocutory or final, whether incidental to a proceeding for divorce, legal separation, separate maintenance, or otherwise. Emphasis added, the court held that the above sections authorize both the finding and the enforcement of duties of support which have not been previously established in another proceeding. Clarkston, Supra, p. 1096. The court noted that a trial court sitting in a Euresa proceeding necessarily first must decide whether he respondent is the child's father in determining whether such person owes a duty of support to a child born out of wedlock. Since the Oregon Euresa authorizes the courts to find, as well as enforce, a duty of support, the court held the authority to establish paternity as clearly implied. See also 81 Al 3D 1175, 1181, 1975. Moody v. Christiansen, 306 NW2D 775, lower 1981, Sardnes v. Sardnes, 106 RI 469, 261 A2D 22, 1970, State of Lower Exral. Norman v. Troutman, 623 SW2D 269, Mo.App. 1981, Brown v. Thomas, 221 Tennessee. 319, 426 SW2D 496, 1968, Yetta v. Com, 84 Wash.2D 155, 524 P2D 901, 1974, M. V. W. 352 Mass. 704, 227 NE2D 469, 1967, in Re Miller, 114 Nis 2D 304, 1952. In states that have adopted the 1968 revisions to the Act, it is clear that the court has jurisdiction to determine paternity, but it is also clear that the court has great discretion to refuse to exercise that jurisdiction. If the obligor asserts as a defense that he is not the father of the child for whom support is sought, and it appears to the court that the defense is not frivolous, and if both parties are present at the hearing or the proof required in the case indicates that the presence of either or both of the parties is not necessary, the court may adjudicate the paternity issue. Otherwise, the court may adjourn the hearing until the paternity issue has been adjudicated. Once it is determined that the court possesses jurisdiction to determine paternity in the Euresa proceeding, the next issue is to decide whether Euresa or the procedure contained in the state's civil paternity statute applies. There is not ample case law from which to draw any solid conclusions, but it appears as though courts will graft the procedures and protections of the state's paternity statute onto the Euresa statute. For instance, in Lee v. Lee, 442 Nis 2D 904, 110 Miscellaneous.2D 623, 1981, a New York court held that blood tests could be ordered despite the lack of specific authority in the Act. Several courts have held that the alleged father is entitled to a jury trial on the issue of paternity, despite the lack of any such provision in the state's Euresa statute. Metz v. State Department of Public Welfare, 430 Sold 401, Miss. 1983, Wallers v. Fry, 205 Neb. 399, 288 NW2D 29, 1980, Clarkston v. Bridge, Supra, Visitation and Custody. Section 23 of the 1968 Act states, "The determination or enforcement of a duty of support owed to one obligee is unaffected by any interference by another obligee with rights of custody or visitation granted by a court." This provision has been held to prevent the support obligor from defending the Euresa action by complaining that the obligee is denying him or her court-ordered visitation. Moffat v. Moffat, 165 calories. RPTR 877, 612 P2D 967, 1980. The court in Moffat reached its decision despite concluding that the obligee's denial of visitation was a flagrant violation of the divorce decree, one that would prevent her from seeking enforcement of the existing support order in the divorce action. Many states have not enacted the 1968 amendments or have chosen not to incorporate Section 23. In these states, a public policy analysis must decide the issue. The purpose of Euresa is to secure support for dependents from those who owe them this legal responsibility. Nowhere in the Act is the prosecutor charged with the duty of enforcing or defending visitation or custody claims. Euresa is a special procedural statute designed to provide a convenient forum for the efficient resolution of support disputes. The only issue in most cases is the amount of support that should be paid. Nevertheless, visitation and custody issues occasionally have surfaced during the course of Euresa cases. Many courts have denied the visitation/custody defense by holding that the obligee does not submit to the jurisdiction of the responding court for these issues, or that the court does not possess subject matter jurisdiction under the statute. See Pfeiffer v. Pfeiffer, Graft v. Hertz, Gross v. Gross, Hoover v. Hoover, Brown v. Turnblum, all supra. Other courts have refused to allow the defense by applying their own state law separating support from visitation/custody. Com. v. Mexel, 201 pascals. Super. 457, 193 A2D 680, 1963, Carr v. Marshman, 195 California PTR. 603. 147 calories. App. 3D 1117, 1983, State Ex Rel. Hubbard v. Hubbard, 110 Wis. 2D 683, 329 NW 2D 202, 1983. On the other hand, State of New Jersey v. Morales, 35 Ohio App. 2D 56, 299 NE 2D 920, 1973. Is frequently cited as authority for joining the issues of visitation or custody with the issue of support. The Ohio court held that the obligor legally could withhold support for the child because he had legal custody of the child. The obligor was prepared and willing to assume actual custody, and it was not the father's desire that their children be public charges. State of New Jersey at 923. The court noted that, where there is a judicial order relating to the custody of minor children, that order has the effect of law and is that which should determine the obligation of the respective parents to their minor children. 299 NE2D at 924, in Accorda Heathcox v. Heathcox, 246 SC2D 444, Georgia 1978, Campbell v. Campbell, 126 Arizona 558, 617 P2D 66, 1980, State Ex Rel. Arneo v. Guerrero, 517 P2D 526, Arizona. 1973. Two courts have held that legal custody in the absent parent does not prevent the responding court from finding the existence of a duty of support and entering an order. State of Louisiana Ex Rel. Eaton v. Hills, 354 NW 2D 209, Wis. App. 1984, County of Clearwater, Minnesota v. Petrash, 198 Cullo. 231, 598 P2D 138, 1979. Other courts have refused to consider custody and visitation defenses where the children are being supported by another state's welfare agency, holding that the custodial parent's conduct should not be transferred to the welfare agency or that the custodial parent's destitution is a change of circumstances justifying a reappraisal of the support issue. McCoy v. McCoy, 374 NE2D 164, Ohio 1977, Bgum v. Bgum, 201 A2D 889, NH 1964. A few states allow visitation and custody defenses in interstate cases. As a result, An interstate case occasionally will involve a rendering state that recognizes the dependency between support and visitation or custody and a responding state that holds the issues to be separate. Euresa provides that the law of the state where the obligor resided during the period for which support is sought controls regarding the existence of a duty of support. 39 Thus, normally the law of the responding state will control. However, if the obligor was present in the initiating state for a portion of the time, or if he or she returns to the initiating state and obtains a modification suspending his or her support obligation, the result changes. See Shannon v. Sterling, 248 Minnesota. 266, 80 NW 13, 1956. Emancipation. Emancipation becomes a troublesome issue in interstate cases when a conflict exists similar to the one discussed in the previous paragraph. If the duty of support in the initiating or rendering state is different from that of the responding state, the responding state's law should apply during periods in which the obligor has resided in the responding state. Federbush v. Mark Twain State Bank, 575 SW2D 829, Mo.App. 1978. Burney v. Vance, 17 Ohio Miscellaneous 307, 246 NE2D 371, 1969. Countermotions to modify. On occasion, an obligor will file a countermotion to modify an existing support order of another state asking the responding court to grant retroactive or prospective relief. Such a tactic calls into play several complicated issues, ones with which appellate courts have not dealt in a clear manner. The 1950 version of the Act, as amended, provided, no order of support issued by a court of this state when acting as a responding state shall supersede any other order of support. The 1968 version of the Act amended the provision to provide, a support order made by a court of this state pursuant to this Act does not nullify and is not nullified by a support order made by a court of this state pursuant to a substantially similar Act or otherwise or any other law, regardless of priority of issuance, unless otherwise specifically provided by the court. Emphasis added. The underlined phrase of the revised Act appears to confer some jurisdiction on the responding court to nullify an existing order of another state. No reference to modification is made. The original language better states the philosophy behind the Act. The hearing in the responding jurisdiction is a de novo hearing. Most of the existing decisions have recognized this concept, and have allowed the responding court to enter an order in a different amount, without affecting an existing order. See Chisholm v. Chisholm, 197 Nib. 828, 251 NW2D 171, 1977, State on behalf of McDonnell v. McCutcheon, 337 NW2D 645, Minnesota. 1983, Stubblefield v. Stubblefield, 272 SW2D 633, text.sif. App. 1954, DeFeo v. DeFeo, 428 A2D26, Dell.fam.ct. 1981, Moore v. Moore, 252 Lower 404, 107 NW2D 97, 1961, Sullivan v. Sullivan, 98.3 App.3D 928, 424 NE2D 957, 1981, Davidson v. Davidson, 66 Wash.2D 780, 405 P2D 261, 1965, Olson v. Olson, 534 SW2D 526, Mo.App. 1976, State Ex-Rel. Swan v. Shelton, 469 SW2D 943, Mo.App. 1971. Many courts have confused the authority to enter an order in a different amount, having no effect on an existing order, with authority to enter a modification of that order. See for example in Remarriage of Pope and Hijra, 160 calories. RPTR. 379, 99 calories. App.3D 514, 1979. Bird v. Bride, 36 Connecticut. Sup. 601, 421 A2D 878, 1980, Campbell v. Jen, 563 P2D 574, Montana 1977. This construction destroys the efficacy of the Part 3 Euresa procedure, which was designed to provide the support obligee an additional enforcement mechanism that does not require the children's rights in an existing decree to be risked in. an ex parte proceeding without an opportunity to submit live testimony. Such a proceeding always has been available through statutory registration procedures and common law actions for debt based on an out-of-state judgment or order. More importantly, the level of representation a prosecutor can provide an out-of-state custodial parent regarding issues not addressed in the petition and testimony form is generally inadequate. Due to heavy caseloads and lack of access to witnesses, the prosecutor should not be put in the position of defending these existing rights. Jurisdiction in another court in the responding state. Often the state in which the obligor now resides is the state where the duty of support arose. Another court in the state, or perhaps in the same judicial circuit, already may have exerted jurisdiction over the parties with respect to the same issues. In such a situation, the obligor may respond to the incoming Euresa by filing a motion to dismiss, arguing that the original court retains exclusive continuing jurisdiction over the support issue. This argument generally has failed by virtue of Euresa's status as an additional or cumulative remedy. Euresa, 9 AULA seconds 3, Olson v. Olson, 534 SW2D 526, Mo.App. 1976, People X Rel. Argo v. Henderson, 97-3 App.3D 425, 422 NE2D 1005, 1981. This is true even if the responding court is the same court that entered the prior order. In that situation, the obligee has a choice. He or she can attempt to enforce or modify the existing order, or he or she can seek the entry of a new, independent order through Euresa. Ray v. Pentlicki, 375 So 2D 875, Fla. App. 1979, Paul v. Paul, 439 SW2D 746, Mo. 1969. Constitutional defenses. Several arguments have produced appellate decisions regarding the constitutionality of the Euresa procedure. The following arguments have been made and rejected: that Euresa constitutes an unlawful agreement or compact between states without the consent of Congress. Or v. Ayres, 301 SW2D 790, Mo. 1957, Fraser v. Fraser, 415 A2D 1304, RI 1980. That the proceeding in the responding jurisdiction deprives the obligor the right of confronting his or her adverse witnesses as guaranteed by the Sixth Amendment to the U.S. Constitution. Gambino v. Gambino, 396 Sode 434, La.App. 1981, Saunders v. Saunders, 650 SW2D 534, Text.sif.app. 1983, Robinson v. Robinson, 8 Ohio App.2D 235, 221 NE2D 598, 1966, Com. X Rel. Schaffer v. Schaffer, 175 Pascals. Super. 100, 103 A2D 430, 42 Alp 2761, that the independent determination of the support obligation in the responding jurisdiction in a Part 3 Euresa proceeding violates the full faith and credit requirement. Taylor v. Taylor, 175 calories. RPTR. 716, 122 calories. App.3D 209, 1981. That the lack of notice given to the obligor regarding the time and place of the hearing in the initiating state violates his or her right to due process. Or v. Ayres, supra. That by allowing a non-resident to maintain an action without subjecting himself or herself to the jurisdiction of the responding court for other purposes, Euresa violates the obligor's right under the 14th Amendment to equal protection of the laws and abridges his or her right to enjoy the same privileges or immunities as other citizens. Harmon v. Harmon, 160 calories. App.2D 47, 324 P2D 901, 1958. That the provisions of the Act defining duty of support are void due to vagueness. Harmon v. Harmon, supra. That by allowing an obligee to bring suit for child support despite the existence of a divorce decree that does not provide for support, Euresa is an ex post facto law and impairs the obligation of contracts in violation of Article 1, Section 10 of the U.S. Constitution. Smith v. Smith, 131 calories. App.2D 764. 231 P2D 274, 1955. The support order. If the prosecutor submits competent evidence pertaining to each allegation contained in the petition and counters all defenses posited by the obligor, the court enters a support order at the end of the hearing. In most states, the order may include a determination of arrearages due and owing on an existing order, assuming the determination was prayed for. in addition to the new, independent order for current support in interest of Solomon, 546 SW2D 129, text.sif.app. 1977, Mancini v. Mancini, 136 VT. 231, 338 A2D 414, 1978, People X Roll, Etchen v. Etchen, 92 3 App.3D 699, 416 NE2D 278, 1981, Smith v. Smith, 3 Hor. App. 170, 647 P2D 722, 1982. This is true even if the arrears do not possess the status of a judgment in the rendering state. Bailey v. Guz, 655 P2D 764, Alaska 1982. The court must require in the order that the obligor make the payments to the clerk of the responding court or other agency authorized by the statute. The court may require the obligor to put up a cash bond to secure payment of the order or subject the obligor to any other terms or conditions that are proper to secure compliance, either through this authority, or by specific authority contained in the state's wage withholding statute. The obligor should be subject to wage withholding to the same extent as is an obligor in an interstate case. Once the order is entered, the responding court must transmit a copy to the court in the initiating state. When the obligor makes payments to the court clerk as per the order, the clerk must forward them to the designated official in the initiating state, who will distribute them to the obligee. The obligor receives credit for the payment on all existing support orders. Enforcement. If the obligor fails to comply with the order, the responding court may punish the obligor for contempt or enforce the order as it would enforce any other order of the court. If the case is a 4D case, it should be treated similarly to other 4D cases. The responding 4D agency should monitor the obligor's compliance and take enforcement action on its own volition. It should not be the sole responsibility of the initiating jurisdiction to monitor compliance, nor should the initiating jurisdiction be required to take formal action in order to seek enforcement. Criminal rendition. Euresa also provides for the interstate criminal enforcement of support orders by facilitating the extradition of absent parents who have been charged with the crime of non-support in the requesting state. Euresa calls for the governor in the state where the absent parent is located to surrender the absent parent to the governor of the state where the absent parent has been charged. The rendition is accomplished by the state's usual extradition process, except that demand need not show that the absent parent has fled from justice, that the absent parent was in the demanding state at the time of the offense. Akins v. Turner, 241 Georgia 401, 245 SE2D 660, 1978, in Repace, 250 Georgia 276, 297 SC2D 255, 1982. The intent of these provisions is to allow a state to pursue a criminal action where civil proceedings have failed. Therefore, the governor may refuse to surrender the absent parent where the absent parent has prevailed in a previous support action. The absent parent currently is complying with an existing support order. Also, the governor may delay the criminal rendition of the absent parent if he or she believes that a civil support action would be effective. In order to make these determinations, the governor may order the prosecutor to investigate the case and report whether a support action has been brought previously or if such an action would be effective. Despite these limitations, it has been held that an extradition need not be refused if the obligee has alternative civil remedies. The criminal rendition procedure is an alternative choice the initiating jurisdiction is free to make. Welch v. Strout, 180 NW2D 895, Lower, 1971, Conrad v. McLean, 166 Colorado 568, 445 P2D 222, 1968. Likewise, it is no defense that the initiating jurisdiction previously sent a Part 3 Euresa petition to the responding state and that a court in the responding state obtained jurisdiction over the obligor in a civil proceeding. Ex parte Brito, 172 text.cr.r. 409. 358 SW2D 122, 1962. Registration. Full faith and credit. Under the common law, foreign judgments could be enforced only by new action in the second jurisdiction, where the original judgment was recognized as mere evidence of the debt. The U.S. Constitution has attempted to change the common law rule by providing that full faith and credit shall be given in each state to the public acts, records, and judicial proceedings of every other state. The U.S. Supreme Court has held that only final orders are entitled to full faith and credit, and if the judgment is subject to modification in the state of rendition, it is not a final judgment. Furthermore, the forum state may modify an order still subject to modification in the state that rendered it. As the Supreme Court stated in Harvey v. Harvey, it is clear that the state of the forum has as much leeway to disregard the judgment, to qualify it, or to depart from it as does the state where it was rendered. Therefore, a court may modify the child support order of a sister state being enforced in the forum state to the same extent it could be modified in the sister state. To determine whether the order of a sister state is entitled to full faith and credit, the court must examine the order to see if it reserves the right of modification, the statutes and judicial decisions of the sister state to see under what circumstances the order may be modified. Many states distinguish between arrearages and payments of future installments. Orders are generally subject to modification as to current support on proof of change of circumstances. Orders are generally not retroactively modifiable in states where each accrued and past due payment automatically becomes a judgment. There is a presumption that an accrued payment is final, and unless the presumption is rebutted, the order is entitled to full faith and credit. The obligor may rebut the presumption by showing that the state where the order was rendered requires arrearages to be reduced to a judgment for a sum certain and that a court in the rendering state may forgive all or part of the arrearage. In this case, the order would not be entitled to full faith and credit. However, the fact that the arrearages are not entitled to full faith and credit does not prevent the court from reducing the arrearages to judgment using the principle of comity. See discussion below. The court can apply its own policy regarding the extent to which arrearages should be forgiven. Uniform Enforcement of Foreign Judgments Act. The Uniform Enforcement of Foreign Judgments Act, which has been adopted in 19 states, gives detailed procedures for seeking enforcement of a foreign judgment, as follows. The judgment creditor files an authenticated copy of the foreign judgment with the clerk of the court in the forum state. The clerk of the court sends notice of the filing to the judgment debtor. The judgment may be enforced as any other judgment of the forum state after a certain period of time has elapsed. The judgment debtor may receive a stay of execution of the foreign judgment if he or she can show that an appeal has been taken in the rendering state. With this procedure or some other procedure adopted by a particular state, valid judgments, including those for child support, are entitled to full faith and credit unless the judgment was rendered without jurisdiction. The judgment was rendered by a court lacking competence to render it. The judgment was not final under the law of the rendering state. The amount of the judgment has not been finally determined under the law of the rendering state. The judgment has been vacated in the state of rendition. The judgment is subject to modification in the state of rendition. Again, the Constitution does not forbid the enforcement of such a judgment and a court is free to recognize or enforce a judgment that remains subject to modification. Registration of foreign child support orders under Euresa. Even though a support order is not entitled to full faith and credit, it still may be registered and enforced under Part 4 of Euresa. 597 Sections 3541 of Euresa, which were added to the Act with the 1958 amendments, provide the following procedure for the registration of foreign support orders. The person wishing to register the order must send to the clerk of the court 3 copies of the order to be registered, a copy of the Euresa law of the state that rendered the order, a statement, or petition, in some states, verified and signed by the person indicating the last known address of the absent parent, the amount unpaid, the description and location of the absent parent's property subject to execution, and a list of states in which the order is registered. The clerk must then docket the case and notify the absent parent. The absent parent has 20 days to petition the court to vacate the order or stay the enforcement. If no such petition is filed, or if the court refuses to grant relief, the court confirms the registration and the amount of arrears. Upon registration, the order has the same effect as any other support order issued by the registering state. The registration procedure offers the Child Support Enforcement Agency at least 5 advantages over other alternatives. First, the statute allows for registration of orders that are not entitled to full faith and credit. Thus, the registered order can be enforced for current and future support, and for arrearages based on an order from a state that allows retroactive modifications. Second, registration is very fast. The order is registered, and enforcement proceedings may begin upon filing in the obligor's state. Third, the obligor's defenses are limited to those available to a judgment debtor in an action to enforce a foreign money judgment. These generally relate only to the validity of the foreign judgment, such as lack of jurisdiction, unconstitutionality, or other procedural defect. Fourth, registration is available to obtain jurisdiction over the obligor's property that is located in a state other than the state in which he or she resides for the limited purpose of enforcing a foreign support judgment. Personal jurisdiction over the obligor is not required for registration, which is a ministerial act of the court in no way affecting the obligor's liberty or property interests. Fleming v. Fleming, 49 N.C.App. 345, 271 SC 2D 584, 1980, Pinner v. Pinner, 33N.C.App. 204, 234 SC 2D 633, 1977, when the obligee attempts to enforce the order, the court must determine whether jurisdiction exists over the obligor or his property, and the amount of the arrearage. If the order was rendered in an automatic judgment state, and if authenticated court records from that state are available to substantiate the amount of the arrears, there should be no due process problems in seizing the obligor's property without jurisdiction over his person. See Higgins v. Dienhardt, 645 P2D 32, Arizona.App. 1982, Legaway v. Legaway, 681 P2D 309, 312, Alaska. 1984, 5th. The obligor does not automatically obtain a redetermination of his support obligation, as is the case with Part 3 Euresa Proceedings. Balanced against these significant advantages are two significant disadvantages. First, the procedure is rarely used, and court personnel are often unaware of the procedure to register an out-of-state order properly. Judges and court administrators should take steps to ensure that appropriate court personnel are adequately trained. The second problem is more significant, and has led many attorneys in the child support enforcement program to forsake the use of the Euresa registration procedure. By registering an out-of-state order, the obligee may become subject to the jurisdiction of the registering court for purposes of modification. Furthermore, a modification of the registered order also may effect a modification in the rendering state. See Allig v. Allig, 255 SC 2D 494, VA. 1979, Monson v. Monson, 85 Wis.2D 794, 271 NW 2D 137, 1978. One Texas case has held the contrary, noting the Euresa registration procedure would fail in its purpose if such a construction of the statute were allowed. O'Halloran v. O'Halloran, 580 SW2D 870, text.sif.app. 1979. Requests for enforcement of an existing order. Sometimes an order already exists in the jurisdiction where the absent parent resides. The Social Security Act, 42 U.S.C. 654 9c, requires that each state cooperate with any other state in securing compliance by an absent parent residing in such state, whether or not permanently, with an order issued by a court of competent jurisdiction against such parent for the support and maintenance of the child or children or the parent of such child or children. With respect to whom aid is being provided under the plan of such other state. Clearly, the state where the absent parent resides already has an obligation under the federal statute to enforce an existing order. Some 4D attorneys prefer to enforce the existing order instead of wasting both courts' time establishing a superfluous order through a Euresa proceeding. Other 4D attorneys argue that a Euresa proceeding is necessary in this situation for one of two reasons. 1. They do not possess standing or statutory authority to represent an out-of-state custodial parent in a non-Euresa proceeding, or 2. They fear the non-Euresa proceeding because they believe they are more in need of a live witness in such a proceeding than in a Euresa case. The first argument should not be true. The federal statute clearly requires the state to enforce existing orders. This should confer standing in state court. Would be a bizarre state of affairs if a 4D attorney were authorized to enforce an out-of-state order but was powerless to enforce one issued by the local court. Euresa is merely a procedural statute. The 4D attorney should derive his or her authority through the statute or cooperative agreement that defines his or her relationship to the 4D agency, not through Euresa. The 4D attorney, as legal representative of the 4D agency, should have authority to bring any action the 4D agency has standing to bring. The second argument should not be true either, but for practical reasons often is. Except in states where the Euresa proceeding is treated as a show cause hearing, there is nothing different about a Euresa case as far as problems of proof are concerned. As noted above, the petition and testimony forms are not admissible as evidence. If the obligor contests his or her liability, the 4D attorney has the same evidentiary problems he or she would face in enforcing an existing order. In practice, this distinction between Euresa and non-Euresa cases is not always maintained, so there may be some actual strategic advantage to using the Euresa procedure. The greater concern among 4D attorneys is that a counter-motion to modify is more likely in a non-Euresa enforcement proceeding because the jurisdiction of the court is limited by the Euresa statute. Although this should not be true, It often is. The court's jurisdiction over the cause of action that produced the original order most likely continues into the future, so the obligor's attorney would have little difficulty avoiding the limited jurisdiction of the Euresa proceeding by simply filing the motion of modification in the other cause. Nevertheless, many jurisdictions firmly hold that Euresa is the only way to go in this situation. Other jurisdictions prefer a well-documented request for enforcement of the existing order over a superfluous Euresa proceeding. The latter procedure should predominate after implementation of the interstate wage withholding procedure mandated by the Child Support Enforcement Amendments of 1984. The number of superfluous Euresa proceedings should diminish with the advent of this more efficient interstate enforcement procedure. Petition in federal court. Pursuant to 42 U.S.C. 660, the U.S. District Courts have jurisdiction without regard to the amount in controversy to hear and determine any civil actions certified by the DHHS Secretary under Title 4D of the Social Security Act. Certifications must be requested by a state 4D agency and must include evidence of the following: the state in which the absent parent resides has not undertaken to enforce an existing order against the absent parent within 60 days of receipt of the request by the originating state under uniform reciprocal enforcement of support procedures or other legal processes required by 45 CFR 303.7. 3. Use of the U.S. District Court is the only reasonable method of enforcing the order. As a condition to obtaining the certification from the DHHS, the 4D agency of the initiating state must give the 4D agency of the responding state, no sooner than 60 days after first seeking assistance enforcing the order, a 30-day warning of its intent to seek enforcement in federal court. If the initiating state receives no response within the 30-day time limit, or if the response is unsatisfactory, the initiating state may apply to its Oaks Regional Office for certification. The application must attest that the above requirements have been satisfied. On certification of the case, a civil action may be filed in the U.S. District Court. The certification should be accepted by the court as sufficient evidence that permission has been granted for use of the federal courts. The action may be filed in the judicial district where the claim arose, where the plaintiff resides, or where the defendant resides. Other alternatives. In most cases it will be possible for the 4D agency to enforce an obligation by relying on interstate wage withholding, Part 2 Euresa actions, or some form of registration. Unfortunately, there will be a few cases that fall through the cracks due to lack of cooperation in the absent parent's jurisdiction, lack of good location information to allow for service of process, or similar problems. If an order exists, especially if the order exists in the state that wants enforcement, there are a few additional options. It may be possible for the 4D agency to avoid the interstate process entirely by locating an asset of the obligor, such as wages, that can be reached within the state, and garnishing them. See Chapter 8 for a discussion of garnishment of wages earned out of state but paid by a corporation that does business in state. It generally will be possible to refer the case for full collection by the IRS. If the crime exists in the state, the authority exists in the 4D attorney, and the elements can be proved, it is possible to file felony non-support charges against the absent parent and get a warrant issued and placed in the interstate computer network maintained by law enforcement agencies. Alternatively, the case will be certified to the IRS for interception of the absent parent's federal tax refund. International cases. The problems faced by states when attempting to enforce an order when the parties reside in two different states are magnified where the parties reside in two different countries. Some states have been successful in obtaining mutual covenants with other countries, and can process cases through the Euresa process. Where no such arrangement exists, the process is difficult and must be negotiated on a case-by-case basis. Outgoing cases. When the absent parent leaves the United States, both location and enforcement can be difficult, but not impossible. If the absent parent is a United States citizen, the State Department can be a valuable ally in the location effort. American embassies throughout the world, on request, will search their records and ask the host country to check its records for information on absent parents believed to be residing there. In addition, the U.S. Passport Services Office in Washington, D.C., will cooperate by furnishing the addresses and possible destination listed on a passport application. Each such request must cite the U.S. statute under which the state or local 4D agency operates, PL 93 to 647, the absent parent's name, date, and place of birth, his or her parents' names, and his or her last known address with the date for which the address was valid. All requests should be in writing and should include all information the state parent locate service has on the absent parent. If the absent parent is not a U.S. citizen, The embassy or consulate maintained by his or her country's government in the United States is a valuable ally. Often it can assist in locating the absent parent and can identify agencies in the relevant country that can assist in enforcement. Incoming cases, where an order has been issued by the other country and has been, or can be, translated so the state court is able to understand its terms. The doctrine of comity allows the state court to enforce it. To allow the court to invoke the doctrine in the case, a petition must be filed alleging the following 5 facts. The foreign order was based on grounds or elements that could reasonably lead a court in the forum state to find that a duty of support exists in the amount ordered. The foreign court had personal and subject matter jurisdiction requisites to enter the order. The obligor was provided with notice sufficient to comply with the foreign court's due process requirements. The foreign court acted in compliance with its own rules. The public policy of the forum state supports enforcement of the order. Once the order is proved, it is entitled to a presumption of validity. See Buend v. Buend, 17 calories. 2d 117, 109 p2d 701, 1941, Anno, 132 ALR 1272, Venator v. Venator, 512 SW2d 451, 1974, Urbanek v. Urbanek, 503 SC2d 434, 1973. The usual enforcement remedies available in the forum state can be used to enforce the order.